Reactions have continued to trail the position of the senior advocate of Nigeria, Femi Falana, stating that former president of Nigeria, Goodluck Jonathan, is not qualified to contest for president again, going by the stipulations of the Nigerian constitution. Well, according to him, the relevant constitutional provision is clear on the status and legibility of someone who is sworn into office to complete the term of office of another, and as such, a person is unworthy by the letter and spirit of the laws of the land to be sworn in a second time. All right, let's deepen the discussion now as another senior advocate of Nigeria, Robert Clark, and lawyer and former president of Committee for Defense of Human Rights, CDHR, Malachy Ugwumadu joins us. They both join us, of course. Let me start with the senior advocate of Nigeria. Thank you both, gentlemen, for joining us on News Night. Well, it almost looks like a deja vu because in 2013, Goodluck Jonathan, the question of whether he's eligible to contest or not actually was the case. But let me bring this, quote it if I can. A person who was sworn in to complete another's term shall not be elected to such office for more than a single term. Now, does this law, this section 137 sub 3, does it apply in the case of former President Goodluck Jonathan? And exactly when does the law take effect? Senior Advocate Robert Clark.
Thank you very much. One has to look at Jonathan's case from two perimeters. One has to look at his case in 2013, and one has to look at his case as of now and what the position is as of now. Jonathan, in completing Yar'Adua's case, consumed about 1.5 years of the 4-year term of Shehu Yar'Adua. The Constitution of Nigeria then, unamended then, said that a president of Nigeria can only serve 2 terms of 4 years each, which means a maximum year of 8 years. Now, Jonathan, at the time Shehu Yar'Adua died, did 1.5 years, and again he became president and did 4 years, making 5.5 years. During that period, I, Robert Clark, was asked to lead some certain lawyers whether we could have Jonathan restricted from contesting the elections. My opinion then, before the amendment, was that when the former Vice President Atiku became the governor of Gongola State, Obasanjo wanted a vice president. And based on Atiku's experience, his wherewithal, he decided to appoint him as his vice president. Now, the deputy governor went to court and said, look, I don't need to hold any other election before I assume Atiku's position as governor. The Supreme Court then said, when a governor and his deputy, or the president and his deputy, run for an election, they run on one single ticket. That was the pronouncement of the Supreme Court. So now, the Supreme Court idea was therefore that the deputy governor can easily mount in as governor in Atiku's position. Now, the Constitution says a president cannot serve more than 2 consecutive terms of 8 years. So, if Jonathan was allowed to contest, it means if he had won, he will have clocked in more than the 8 years stipulation in the Constitution. Will that have amounted to an illegality? Even though the Constitution, as of today, allows a president to serve more than 8 years. For instance, in the position Nigeria is today, the president can ask, if it is impossible to hold elections, can ask the National Assembly to extend his term by 6 months until the situation was favorable for an election to be held. So it is wrong for any lawyer to think that the 8-year period is sacrosanct. No. Any president in Nigeria can spend more than 8 years if elections are impossible to be held.
All right.
Now, amendment has been made in the Constitution now. And it is clear that what happened in Jonathan's time in 2013 or 14, if it reappears now and any party decides to bring Jonathan in, it will be caught by the provision of the amendment, which says that any vice president that serves out the remainder of its former president can no longer, under the present law, be allowed to contest.
Okay.
So far as
Nigeria, let me bring in our other guests on the news tonight. Thank you so much for your view so far. Mr. Malachy, some people argue that, you know, just as the senior advocate was saying in his last speech, former President Jonathan was completing the tenure of President Musa Yar'Adua, I beg your pardon, and that this should not be applied. And again, former President Jonathan contested the 2015 elections. Does that mean that it would have erred from all of this argument? What are your thoughts?
Well, I'm largely in sync with the position that the senior advocate has just canvassed. Because as it were, the situation is bifurcated between the earlier position before the amendment of the Constitution and what it is at the moment. What has generated the controversy so far is whether the law, which was amended in the Constitution, speaking about Section 137, subsection 3, can operate retrospectively. And the resolution of that narrow concern is what has become a very convoluted debate amongst us as lawyers. My take is straightforward. It is that the language of the law and the intent of the law, as carefully crafted, clearly, captures the intention of the legislatures with respect to persons who has served out the remainder period of the substantive president who has ceased to be the president of the country for one reason or the other. In the case of Jonathan, it was on account of the death of President Yar'Adua that saw him taking the oath of allegiance and the oath of office, since there cannot be a vacuum. That provision speaks about that situation. And then his subsequent context of the same position in 2015 was interpreted, as it were, to be the second taking of the oath of allegiance and the oath of office. That for me is where we are today. And the Supreme Courts have had, opportunities in previous cases, as already in the public domain, to deal with these matters one way or the other.
So let me take this back to the senior advocate, Robert Clark. I mean, is this a case of much ado about nothing? The fact that this is even being discussed at all in the first place, is it an indication that the Constitution is vague as far as this section 137, 3 is concerned? Is that what it is? Is there a need to go back to the Constitution?
Practically speaking, the Constitution must be operated as it is, not as it were, or for whatever reason. We have to read it. The Constitution says, once a president dies and somebody else who is his vice president, runs out the remainder period, he can no longer take another term. That is what the law says today. And courts are enjoined to interpret that constitution as it is today. Whatever had happened 5 years ago, 10 years ago, are no longer relevant in any court looking at that provision of the law. If 10 years ago, the law says if you steal a Bible, you cannot be convicted. If you steal a Quran, you cannot be. But if within the period of 10 years, the law now says you can be executed. Any other person who now comes to steal the Bible or Quran will be executed in accordance with the prevailing law. As of today's date, the prevailing law is clear. Therefore, I agree with Falana. I'm not saying they are making any ado about nothing, because we lawyers will still go to court to fight it out. But one thing I want to point out to Nigerians, and one thing I want to point out to the two major political parties, the position of the president of a country is so high that you don't play gambles with it. I have been Jonathan's lawyer for over 16 months after he left office. I will not advise him, as of now, as Robert Clark, to go and contest election, when I know that that section that is in the Constitution today can be challenged and it can go anywhere. So I will advise that we take the law as it is, operate the law as it is, and prevail on any political party not to dance around that issue, because they may have to go to court. If Jonathan comes back today, he wins, definitely there will be a floodgate of litigation. Is that what is confronting Nigeria today? No. We better forget and pick somebody else who is purposeful, who is going to take us from all these shambles in which we are in Nigeria today, and we look forward to a better Nigeria.
Indeed.
Not allow these political rascals to start bringing obstacles that will not be taking us into all the courts up to the Supreme Court.
Indeed.
My position is clear. Let Jonathan go and sit down.
Thank you so much, Senior Advocate of Nigeria. Mr. Malachy, I suppose that you agree with the Senior Advocate on the advice to former President Jonathan not to run. Although people say, you know, he's a Nigerian, the Constitution allows him as a Nigerian to seek political office, and of course this controversy. But let's talk about those Senior Advocates of Nigeria have described as political rascals moments ago. The controversial section 84 subsection 12 of the Electoral Act. At the moment, we have 4 ministers in this cabinet of President Muhammadu Buhari who have indicated interest to run for offices but are yet to resign. What are your thoughts?
Well, it has added to not just the absurdity, but the robust nature of the political moment. I have seen, watching very closely, there are quite a number of the Nigerian politicians, albeit those operating at the highest level of governance, state actors for that matter, have become less circumspect than they ought to be. You see, all of these legislative interventions are embarked upon to deal with exigencies that are incidental and consequential to the democratization effort. The argument has been fought and back, but you see, the legislature has sought to correct what they felt is an overbearing influence of the executive in having within them automatic delegates who could swell their chances in congresses, and came up with this legislative position. We're all aware of the legal battle that ensued as a result of that, and the position of the High Court, I think in Umuahia, but that position has also been taken to the Court of Appeal, wherein a stay of the execution of that judgment is what is the position as at today. In other words, we've gone back to the same section 84, subsection 12 of the Electoral Act 2022. The implication of that is that whoever wishes, as a political appointee, as distinct from civil servants or public servants, will have no option other than to comply with the express provisions of the Electoral Act. So when you see, as it were, the, if you like, for want of better words, the recalcitrance of state actors, you begin to wonder to what extent are they ready to take the risk, particularly regarding the financial implications of some of the offices they're vying for at the moment, and depending on the political party that they belong, in advancing their political journey. So for me, that again is clear, even if it is generating controversies. It is that we are back to section 84, subsection 12, as opposed to those who think that it has been overturned. It is only when the Court of Appeal or the ultimate apex court of the country, which is the Supreme Court, takes a contrary position that any one of them can run away from the extant provisions of 8412.
All right, let me bring back in Senior Advocate Robert Clark. I mean, you talked about political rascality earlier. Would you describe as political rascality on the part of the legislature that inserted this section 84 sub 12 into the Electoral Act? You know, where some say by the legislature, by inserting this section, actually, you know, goes beyond its powers, trying to get more powers to itself. Do you agree with that?
Well, experience is always the best teacher. Politicians know themselves. They know the advantages involved in that particular section of the Constitution. You see, most of these public officers who are not civil servants, as my learned colleague has said, are politicians who have come to play politics, reap from politics, and take advantage of politics. So that when conventions are being organized, despite and in spite of the fact that they are eating with their two hands as advisors, as ministers, they still want to participate in the nomination of candidates, taking advantage of the ordinary party member who has been struggling for 4 years to have a hand in the nomination process, being taken by a crowd of public officers being brought in by all these ministers. As my learned friend rightly said, the court has spoken. And until that decision in Umayyad is reversed by the apex court, that is the law in the country. They must have to agree to it. And I am not saying they are rascals in that respect, but they are stretching their law too much and too far. Thank you.
Thank you very much for this conversation. Senior Advocate of Nigeria, Robert Clark, and as well as lawyer and former president of the Committee for Defense of Human Rights, Malachy Ugwumadu. Thank you for being on the news tonight.